Good morning, everyone. Welcome to 3BB's Inquest Series 2 on Article 2, Engagement and Effect. My name is Sharma and I form part of 3BB's Inquest team. And today I'm joined by Susan Jones, who you'll hear from later, on the question of effect under Article 2. 2020 has been a very interesting year for Article 2, and I hope that you'll gauge from us all the different changes that have happened in the last few months. You will see that there is a Q&A tab at the bottom. I'm sure everybody's very familiar with using Zoom now. Please do pop your questions into that tab. We'll do our very best to answer the questions during the course of the webinar. However, there should be some time at the end to answer any of questions that you may have. Obviously, we've started at 10, we finish at 11, and we will be able to send to you our slides at the end of the webinar if you just request them from our marketing team. So without further ado, let's start. Now, you'll all be familiar with the Human Rights Act 1998, because of course, that gave effect in UK law to the European Convention on Human Rights. Some of us will know, some of us will know that it because it came into effect while we were already starting our legal professions, but for others, it will have come into effect, or it didn't exist before we even started in the professions that we undertake now. It has had a profound effect on all areas of law, but the impact on coronial law has been absolutely significant. But I think before we look at it and its impact, it's really important to turn to Article 2 itself and to understand it, because it is arguably the most fundamental provision from the Convention. So what is it? It states that everyone's right to life shall be protected by law, and no one shall be deprived of his life intentionally. Now, of course, there is a caveat to that, and that is save in the execution of a sentence of a court following his conviction of a crime for which the penalty is provided by law. So really that's what we know as the death penalty, and not legal, of course, in the UK or England and Wales, but is in many parts of the world. Now, there are derogations to the deprivation of life, and they are set out, as you'll see, in my bullet point 2. And what it effectively says is that it's not a contravention of this article when it results from the use of force, which is no more than absolutely necessary. And there are three further points that are raised in Article 2 where you can, or there is no contravention of this article. That is in the defense of any person from unlawful violence, in order to effect a lawful arrest or to prevent the escape of a person lawfully detained, and in action lawfully taken for the purpose of quelling a riot or insurrection. But what does this actually mean for the coronial process? What does it mean in coronial law? Well, let's have a look at this. So Article 2 is interpreted as providing two substantive duties and also an implied duty. The negative duty, which is the first on the list, is basically that a state is refrained from taking life. And an example of that is a death arising from a shooting, such as the death of Mark Duggan, for example. Now, you may remember, he was the 29-year-old young man who was shot dead by police in Tottenham. And it was his death that kick-started the 2011 London riots. Another example of the negative duty is the case of Charles de Menezes, the Brazilian man who was shot dead by London Metropolitan Police on Stockwell London Underground. And you'll recall that it was wrongly deemed, at the time, he was wrongly deemed to be one of the fugitives from the previous day's failed London bombings. So in those cases, it's very obvious that Article 2 is engaged. Now, there's also a positive duty, and this is the state's duty to protect life. And this is where most arguments take place under Article 2. It can be done in two ways. The first way is this: having in place a framework of laws, precautions, procedures, and means of enforcement, which will protect life. And of course, that is to the greatest extent that is reasonably practicable. So, for example, having a beach safety framework or a procedure on unmanned beaches. And that was something that was deemed required following the Canberra Sands death. This was the death of 5 men in 2016 who were very strong swimmers, all friends. I think the majority of them were from Sri Lanka, and they drowned while swimming on an unmanned beach. It was following that inquest that it was determined that, in fact, there wasn't the beach safety framework that was required and was part of the state's positive duty. Secondly, taking appropriate steps. So I said it could be done in 2 ways. So the other step under positive duty is the operational duty. And that is to safeguard lives of those whose life is at risk. And this will arise where a particular individual's life is specifically at risk in a particular circumstance. Now, an example is the failure to undertake regular checks on a prisoner who may be a high suicide risk. So you can see examples of this in circumstances where the police are to look after a prisoner. They know he's a high suicide risk. They may have experienced before, they may have seen it from the notes, but they don't undertake those regular checks of him to make sure that he is safe and well. And of course, he commits suicide. And that is an example of an operational duty. Now, the final obligation, or the final duty, I should say, is the implied duty. And that is a procedural obligation on a state to initiate an effective public investigation. So this is an obligation to have a proper and open investigation, which is to be by an independent official body, specifically into the deaths where there is arguably an arguable prima facie case that the state has breached one of the 2 duties, i.e. the negative duty and the positive duty. In the case of Middleton, which was against Her Majesty's Coroner for the Western District of Somerset, it was held by the House of Lords that this procedural obligation for an effective public investigation would generally be discharged by the inquest process, and is what's become known really as the Middleton Inquest. The remit in Middleton Inquest is that where Article 2 is engaged, it extends the question of how the deceased came by his or her death to how and in what circumstances the deceased came by his or her death. So you'll be aware, 4 questions that the coroner has to answer: who's died, where they died, when they died, and generally how. Under Article 2, that question of how is extended. And the dicta of Middleton has been placed on a statutory footing under the Coroner and Justice Act. That was drafted, I should say Justices Act 2009, and that was drafted into Section 5, subsection 2. The case of Mcguire is a case that's really had quite a profound impact on the engagement of Article 2. It was handed down during lockdown on the 10th of June 2020. And what it's really done is confirmed a lot of the case law that's already been heard by the UK courts and the European courts on Article 2 and when it is engaged. But perhaps more importantly, it also looks at the particular obligations under Article 2 when a death occurs of a vulnerable person in the care community. Now, the picture in front of you is the picture of Jackie Mcguire, because of course it's really important to remember that in any inquest, the centre of that is the deceased, the person who has died. And it will be for the coroner to determine how that person, and potentially in what circumstances, if it's Article 2, that person came to their death. So let's just go very briefly through the facts of Jackie's life, because of course it was that those facts that enabled the coroner to determine whether or not Article 2 was engaged. Jackie was a young woman that was born on the 28th of April 1964. Now she had Down syndrome, but she also, in addition to that, had learning difficulties, behavioural difficulties, and also some physical limitations. She lived in a residential care home, and she had done so since 1993, which was managed by United Response. The council, Blackpool, actually paid for and supervised her placement. and the accommodation they provided was for adults with learning difficulties who required personal care. Now, it's important to note that this was not a nursing home. Its staff had neither medical nor nursing training. And Jackie was also subject to what's called a Deprivation of Liberty Safeguards Order, a Dole's Order. Jackie died at Blackpool Victoria Hospital on February the 22nd in 2017, and she was only aged 52. She had suffered from a cardiac arrest, and this had followed, firstly, a perforated stomach ulcer and peritonitis, and secondly, pneumonia. Now, she had been ill 2 days before her death, and it was these facts that the coroner looked at very carefully. On the 21st of February, a call had been made to NHS 111, which resulted in advice to consult a GP. Now, that consultation had happened over the telephone, but there were concerns that had continued later in the evening, and an ambulance was called. The paramedics were very keen on transferring Jackie to a hospital, but she didn't cooperate. There had been a history of Jackie not cooperating with attending medical appointments, such as for blood tests, and that did go into the evidence in the inquest. But a decision was made not to take her to hospital. At the time, an out-of-hours GP was telephoned. Advice was given by the GP that every attempt should be made to persuade Jackie or encourage her to go to hospital, but that if she refused, then she could stay at the care home and be monitored that night and overnight. And that's exactly what happened. She was monitored overnight. She didn't go to the hospital, but very sadly, her condition worsened. The ambulance attended. She was taken to hospital. She was found to be severely dehydrated with kidney failure and metabolic acidosis. She had severe infection, and following that, she died of a cardiac arrest later that day. Now, the family argued that the circumstances of her death were such that there should be an inquest that satisfied the procedural obligation under Article 2 of the European Convention of Human Rights. Now, initially the coroner agreed with that, and evidence was called over a 10-day period in line with the procedural duty. So the entirety of the inquest was effectively conducted with Article 2 in mind, and with the wider question of in what circumstances and by what means Jackie came to her death. But before the jury was asked to perform its function under Section 5, i.e. dealing with the questions of who had died, where they died, when they died, and of course how they had died, the coroner revisited his earlier question and decision on Article 2. And he referred to a recent authority called Her Majesty's, the recent authority of Parkinson, and that had been against the senior coroner for Inner London South. This was a case where a 91-year-old lady had died in A&E, and it had been alleged in that case that she should have received more timely treatment. But in that case, it was specifically found that there were no systemic failures identified by any of the medics or those involved in the care of Parkinson. Now, in Mcguire, the coroner decided that the evidence didn't suggest that Jackie's death might have resulted from any type of violation of the positive duty to protect life that had been imposed by Article 2, and of course what we know as the operational duty. And so with that in mind, he said that the procedural duty did not apply. And so the jury's conclusion of how Jackie came to her death was really simplified and limited to how did Jackie come by her death. That's how that question should be answered, and no more expansive than that. So in those circumstances, the jury actually concluded that Jackie died by natural causes, by way of natural causes. And the jury also produced a very short narrative decision of the events, or a narrative description, I should say, of the events on the 21st and the 22nd of February 2017. So really the lead up to Jackie's death. Now, had the coroner left to the jury the question of the issue of satisfying the procedural obligation under Article 2, the jury could have also expressed a view on the circumstances in which Jackie came by her death in accordance with Section 5, subsection 2 of the 2009 Act. And based on those facts, those circumstances might have included the following issues which had arisen as a result of the evidence. Firstly, that the professionals in the case didn't really appreciate Jackie's life-threatening condition. Secondly, that there'd been at various points in the treatment of Jackie failures in the communication between the medics, between the paramedics, between the out-of-call GP. And thirdly, that there'd been no advanced plan in place to get Jackie to a hospital in the event that she refused to cooperate and if the admission was urgent. And the family thought that this was extremely relevant because there was a history that the care home was aware of that Jackie didn't always attend hospital cooperatively or medical appointments cooperatively. Now, the case was appealed, and it was appealed by way of judicial review to the Divisional Court. In that case, and it was heard by Lord Justice Irwin, Mr. Justice Farby, and His Honour Judge Lucraft QC, that decision was in fact dismissed. And what the coroner concluded was that it wasn't wrong. What the Divisional Court concluded was it wasn't wrong of the coroner to decide that the procedural duty did not arise on the evidence that had been heard at the inquest. Taking it further, Lord Justice Irwin also provided this response, which is really relevant to Article 2 and how it stands in these types of cases. At paragraph 44, he said, "We have reached the conclusion that the touchstone for state responsibility has remained constant. It is whether the circumstances of the case are such as to call a state to account. In the absence of either systemic dysfunction arising from a regulatory failure or a relevant assumption of responsibility in a particular case, the state will not be held accountable under Article 2. The family lodged an appeal to the Court of Appeal, and they effectively issued 3 grounds of appeal, and they were pursued as followed. They said, number 1, that the Divisional Court had erred in concluding that the procedural obligation under Article 2 didn't apply. They said it wasn't a medical case like that of Parkinson. Secondly, they said that even if Parkinson does apply, and you remember that was the 91-year-old lady that I referred to earlier, it was wrong to conclude that the failure to have in place a system for admitting Jackie to the hospital on the 21st of February 2017 didn't amount to a systemic failure. And what the family were really getting at this point was the issue around the fact that Jackie wasn't always cooperative in attending her appointments and to attending hospitals. Thirdly, they said that the Divisional Court had erred in its failure to take into account the wider context of premature deaths of people with learning disabilities. And they said that that was really relevant to the application of Article 2. And what the family had did was they submitted 2 reports on premature deaths of those with learning disabilities. They used that to support the contention that Jackie was owed an operational duty in connection with the medical attention that she received leading up to her death. However, in Jackie's case, that didn't really form part of the evidence in the inquest, as it didn't assist the coroner on the 4 questions to be asked. Now, the decision of the Court of Appeal was as follows. They basically said, number 1, there was no basis for believing that Jackie's death was the result of a breach of the operational duty of the state to protect life. And so they said, well, if there's no breach of the operational duty, therefore the procedural obligations on the state did not rise. So effectively, they're agreeing with the coroner in the first instance. Added to that, they said, secondly, an operational duty is not automatically owed to those who are in a vulnerable position in a care home. So just because Jackie was vulnerable and she was in a care home, it doesn't always mean that just because there's an error by the medics involved, it would lead to Article 2 being engaged. Thirdly, that Jackie's case could be distinguished from someone who was voluntarily a psychiatric patient who was a suicide risk, such as the case of Reborn. And I will come to Reborn in due course because the facts of that are very helpful and interesting. Jackie was accommodated at the care home to be looked after by carers because she couldn't possibly be looked after by her family. She was not at the care home, they said, for medical treatment. And so if she needed medical treatment, it would be sought in the usual way through the NHS. So her situation, it was argued, was no different to the fact that if she was living at home and there was social services input and she was subject to a dole's order. Fourthly, they said a state might be in breach of an operational duty in two exceptional circumstances. Number one, where the state knowingly put an individual's life in danger by denying access to life-saving emergency treatment. And so in this case, it wasn't accepted that the criticisms of the paramedics or the out-of-hours GP satisfied the first exception, that Jackie's life was knowingly put in danger by denying her access to life-saving emergency treatment. And secondly, where there was a systemic dysfunction that resulted in a patient being denied access to life-saving treatment in circumstances where the authorities knew or ought to have known of the risk but failed to take preventative measures. And again, the Court of Appeal didn't accept that this was a case which raised systemic or structural dysfunction in the medical services, and therefore resulted in Jackie being denied life-saving treatment. And so really what the outcome of this case is the fact that just because there is some sort of medical mishap or medical negligence, whether it's by one individual or many individuals during the course of the treatment of a person, or the deceased in this case, that wouldn't necessarily engage Article 2. And of course, it has a really large impact on cases where there are deaths in care homes of vulnerable individuals, and of course, deaths of individuals in a hospital or a trust environment. The court also referred to a case of Lopes de Sousa Fernandes in Portugal, and this had been a case that was referred to quite strongly at paragraphs 195 to 197 in the judgment of Mcguire. This was a case where a man was alleged to have died as a result of various instances of medical negligence. But what the court determined on that occasion was that there was no failure of the regulatory framework for providing care. And what they said was the dysfunction at issue must be objectively and genuinely identifiable as systemic or structural in order to be attributable to the state authorities, and must not merely comprise individual instances where something may have been dysfunctional in the sense of something going wrong or functioning badly. The dysfunction at issue must have resulted from a failure of the state to meet its obligation to provide a regulatory framework in the broader sense indicated above. And that comes directly from the judgment of the Grand Chamber. Now, the other very useful thing about the case of Mcguire is that it refers to a number of cases and provides guidance of when Article 2 can be engaged, so when it does apply and when it doesn't apply. And why this is useful is because it can really assist that when us as lawyers are looking at whether we can argue on behalf of our clients that Article 2 is engaged, or perhaps if we're acting for a trust or a care home or any other state-owned organisation, these cases really provide assistance to help us determine whether we can argue those cases for and against. So let's deal with the cases where Article 2 is said to apply and explore the facts of some of those. The case of Reborn and Pennine Care NHS Foundation Trust. Now, this case was also referred to in the Divisional Court and was looked at by Lord Justice Irvine in the case of Mcguire. And in that case, Melanie Reborn had been admitted to a psychiatric hospital because she was suffering from a psychiatric condition. She had in fact previously attempted to commit suicide. Now, the court found that there was a marked contrast with her circumstance and patients in a hospital for treatment or for surgery, because a psychiatric patient was someone who really presents a real and immediate risk of suicide. And so Lord Dyson observed in that case that the Strasbourg jurisprudence shows that there is such a duty to protect persons from a real and immediate risk of suicide, at least when they are under the control of the state. So that could be, as I said, in the psychiatric hospital. It could be when potentially someone is under CAMS, medical health team, or anything of that nature where it's somebody has a real and immediate risk of suicide and it's known to the state are in control of protecting that person, then Article 2 would apply. Nancheva and Bulgaria is an interesting case where there were 15 disabled children who died in a residential home. The authorities there were aware of the appalling conditions of that home and that there was an increased mortality rate of children. They were found, the state that is, to be in breach of their positive obligation for failing to take prompt action in relation to protecting these young people. So that was a real obvious case where Article 2 was engaged. Then the case of Watson, United Kingdom. In that case, it was concluded that a badly managed transfer of elderly residents of a care home could have a very negative impact on the life expectancy of an individual because of as a result of the fact that elderly residents have general frailty and of course they have resistance to change. And so in that case, it followed that Article 2 could be applicable. Now, where there's been a duty, where a duty is said to not have applied are in the following circumstances. The case of Lopez, which we've looked at very briefly, but just to sort of expand on the facts, just so we can understand it a little bit better. In Lopez, Mr. De Souza Fernandez was a 40-year-old man. He'd had a routine surgery to remove his nasal polyps. And sadly, as a result of that routine surgery, he died. His widow had argued that his death was a result of a hospital-acquired infection and the negligence in his post-operative care that was given. Now, the Chamber of Strasbourg Court agreed so the Chamber of the Strasbourg Court, which is the middle court, they actually agreed with what the widow put forward, but the Grand Chamber, to whom the case was appealed to, came to a very different conclusion. And they said that in cases involving alleged medical negligence, the state's positive obligations were regulatory. It continued by noting that in very exceptional circumstances, a state may be responsible under the substantive limb of Article 2. And the case of Parkinson, again, which we've looked at very briefly, but again, the 91-year-old lady who died in A&E, where there was no systemic failures said to be found, but she should have had more timely treatment. And then finally, the case of Dumpe and Latvia. And this had very similar facts to the case of Mcguire. So it's a really interesting case and one that was looked at very, very carefully by the Court of Appeal in Mcguire. And it related to, again, a very young, vulnerable young man who had Down syndrome and epilepsy. He had died because of a care home's failure to provide him with adequate medical care when his health had deteriorated. There was, in fact, a criminal investigation into the death, and it was identified that there were a number of failings and there were a number of shortcomings in the medical care that was provided, but that didn't give rise to any criminal liability. And even though the health inspector was highly critical of the care given, it even led to members of staff being disciplined, so the care given to the deceased, the court still concluded that the applicant's complaint pertained to medical negligence in the care provided to her son. And of course, as we will know, we have a forum, the civil courts for medical negligence cases, and that is really what the Grand Chamber and even the Court of Appeal is differentiating, that there are these different courts to deal with different issues. And so medical negligence cases is where those cases will be dealt with, and that's why they are distinguished. Now, I want to leave you with a final case, and that is the case of Irocco. And this was against the coroners for the Inner London South. It was a High Court decision, and in that case, it was concluded that the coroner was correct to say that Article 2 is not engaged, not to find neglect, and not to issue a PFD, so a Prevention of Future Deaths report under Regulation 28. Now, the family had a number of concerns in this case. There were concerns about the hospital record keeping, there was a do not resuscitate decision in place, and there was a previous hospital discharge. So all of these concerns were raised during the inquest, but the application, it was said, of these principles to the case in which death has occurred as a result of medical mishap has been subject of much consideration. But as confirmed recently, and of course recently it was referring to the case of Mcguire, and I believe it also referred to the case of Parkinson's, it said it is now well settled. So the case of Iroku really just confirmed what we've already just been through in Mcguire, and much of the decision made by the European courts, as well as our own courts, the High Court and the Court of Appeal, on this issue of when Article 2 is engaged. It's now well settled. It's really clear. I say really clear, arguably it's very clear. When it comes to the negative obligation, I think it will be very obvious. We will be able to still engage Article 2, as I've already outlined. But when it comes to cases of deaths that have happened in certain settings, such as I said, in the care home or in hospitals, those are ones that we are going to have to think of very, very carefully as to whether Article 2 is engaged or not. Susan, I'm now going to turn to you if I can, and I just wanted to ask you, what effect does triggering Article 2 have on inquests themselves?
Thank you, Sunyana. Yes, it's an interesting question as to what effect it has and to why it actually matters. So firstly, the thing to consider is that when Article 2 is engaged, when Article 2 is engaged or is arguably breached, the state has a procedural duty to carry out an effective and independent investigation into the death for which it may bear responsibility. And it's important to be aware that this doesn't necessarily have to be through the inquest process. It can be discharged, the state's duty can be discharged through a criminal trial or a public inquiry. But in this jurisdiction, the coroner's investigation is the normal way for the state to satisfy its procedural obligations. When that is engaged, when Article 2 is triggered, if you meet the thresholds that you, Sunyana, have just described, the question will, of course, be by what means and in what circumstances the individual came by his or her death. And an effect, and an important effect, is that when this is engaged, families will sometimes at that stage feel vindicated that this death is an important one, and on the opposite hand, you can often visibly see families disappointed when a coroner explains that Article 2 is not engaged. But unfortunately for us, that is not the legal test. Many coroners, however, will openly say in court that engagement of Article 2 or otherwise makes little difference to the inquest, and they will, in any event, fully and fearlessly examine the death as they're required. And those kind of open court remarks, they are in keeping with a 2013 judgment from the Court of Appeal against or concerning the Greater Manchester coroner. And in that case, the Court of Appeal set out that there is little difference between an Article 2 and non-Article 2 inquest when scope is concerned. The difference, however, is likely to come in conclusions and findings, and that is what I would like to focus on today. The effect of Article 2 is likely to have an effect, the engagement of Article 2 is likely to have an effect on the record of inquest itself. Narrative conclusions can be used in both Article 2 and non-Article 2 inquests. However, when it comes to narratives or conclusions, the House of Lords in Middleton in 2004 set out that a short form conclusion is not always adequate in a case involving the duty of the state under Article 2. What is of note in Article 2, and it is not new, is that there is a weakened causation test. And that test in Article 2 cases is that the record of inquest can include not only probable but also possible causes of death. And that was established and made clear in 2010 by the Court of Appeal in the Lewis case. Also, any narrative, of course, will be expanded because it will be expected to answer in what circumstances the deceased met his or her death. And further, there can be reference to judgmental words in an Article 2 narrative. Again, this is clear in the Chief Coroner's guidance number 17 on narratives within the Article 2 section. Again, important to remember that even in an Article 2 inquest, the coroner or jury must still avoid answering a question which appears to determine civil or criminal liability. So looking at this in practice, with the particular case of Tainton in mind. Tainton was considered in 2016, and the facts are that Mr. O'Neill, he was a serving prisoner who died of cancer of the esophagus following a delayed cancer diagnosis. Article 2 was clearly engaged in this case, but it is important to look slightly closer at the particular facts that were involved. Mr. O'Neill was remanded in custody in September 2012. He was then sentenced in December 2012 to an 8-year, 8-month sentence. From October 2012 onwards, so at the very outset of his time in custody, he complained of various symptoms to various medical professionals. Despite that complaint, or those complaints commencing in October 2012, he didn't see a GP until the 24th of June 2013. When he attended that GP, the GP rightly made an urgent referral, 2-week referral to a specialist. And on the 2nd of July 2013, Mr. O'Neill was diagnosed with cancer of the esophagus. The scans revealed that that had spread to the liver and right lung. And in late July, he was advised that he had 6 to 12 months to live. Mr. O'Neill didn't live 6 to 12 months, and he in fact died on the 23rd of October 2013. At the inquest, the treating clinician could not tell the coroner whether or not Mr. O'Neill would have been able to tolerate chemotherapy earlier in 2013. She could only tell the court that he was not fit to undergo chemotherapy by the time she assessed him in July. An independent review was carried out of the Prison Health Authority's conduct, and that review found that the time between presentation with symptoms and referral was 8 months. And it concluded that that delay was entirely unacceptable. The majority of these delays occurred whilst Mr. O'Neill was resident at Her Majesty's Prison in Preston, which I understand is the photograph within this slide. I've never had the good fortune or misfortune of visiting. In any event, the report concluded that medical staff in HMP Preston failed to follow up on symptoms. And before the inquest, the relevant medical trust wrote to the coroner, and they accepted that Mr. O'Neill ought to have been referred to a GP in January 2013. They also accepted that had he been referred, he would probably have been diagnosed with cancer around mid-February 2013, but they were unable to say how far advanced the cancer was at this stage. The coroner held this inquest with a jury as required, and those admissions were repeated at the start of the inquest and again in evidence from the relevant witnesses. At the inquest, it was not disputed that the cancer should have been diagnosed 5 months earlier than it in fact was, and it was accepted that if it was diagnosed in February, or it would have been diagnosed in February if Mr. O'Neill had properly been attended by prison healthcare staff. The coroner concluded that the admitted failings were not causative of death and that she could not leave those issues on causation to the jury. Two possible conclusions were left to the jury, They were 1, natural causes, or secondly, open verdict. The jury in Mr. O'Neill's inquest, they returned a short form conclusion, and they recorded that Mr. O'Neill had died of natural causes. The record of inquest therefore made, of course, no references to the admitted, very serious, but non-causative feelings. Mr. O'Neill's mother, Mrs. Tainton, then challenged the senior coroner's decision on a number of issues. Not on topic today, but of interest to some of you might be that there was a challenge by the senior, or by Ms. Tainton, that the senior coroner failed to leave the question of causation to the jury. The divisional court considered that the coroner was right not to do so, given there were too many unknowns. It wouldn't have been safe for that issue to have been left to the jury. Secondly, of interest is that there was a challenge not to leave the issue of neglect to the jury. The divisional court again concluded that the senior coroner was correct not to leave that as a potential finding. But the relevant challenge for today is the question of should the coroner have directed the jury to include non-causative admissions on the record of inquest. And so that issue really turns on the admitted serious feelings, the late diagnosis of cancer. And it's important to remember that it was not disputed that this was death by natural causes, but what was the centre of the issue was the substandard medical care that Mr. O'Neill had received whilst in prison. And in short, the divisional court answered this question with yes. The senior coroner had erred, and he should have directed the jury to include on the record of inquest a brief narrative of the admitted feelings. And in relation to that, the court said this: although these facts were not disputed, we consider the coroner should have directed the jury to include in the record of inquest a brief narrative of the admitted shortcomings of the healthcare staff responsible for the late diagnosis of Mr. O'Neill's cancer. In light of the fact that the coroner withdrew the issue of causation from the jury, such a statement would have to have been supplemented by an explanation that it could not be concluded that these shortcomings significantly shortened Mr. O'Neill's life. So in that paragraph, at paragraph 73 of the judgment, the court was setting out that admitted non-causative feelings should have been included in the jury's record of inquest, and the record should have made clear that those did not cause or hasten Mr. O'Neill's death. But that was not the end of paragraph 73, and the court continued. In this case, such a statement would have completed the incomplete account of the circumstances in which Mr. O'Neill met his death, and would have been a fair reflection of the issues that the inquest had focused upon, even if the issue was left to the jury only on the basis of a choice between a conclusion of death by natural causes and an open conclusion. And in the next paragraph, the court continued, putting the point another way: in an inquest such as this, where the possibility of a violation of the deceased's right to life cannot be wholly excluded, Section 5.1b and 5.2 of the 2009 Act should require the inclusion in the record of inquest of any admitted feelings forming part of the circumstances in which the deceased came by his death, which are given in evidence before the coroner, even if, on the balance of probabilities, the jury cannot properly find them causative of death. And in Tainton, on judicial review before the divisional court, counsel for the coroner argued or submitted that because these criticisms had been publicly aired and admitted in court, the inclusions of these findings on the record of inquest were superfluous. And the divisional court, they rejected that submission, and they said in the present case, without the admitted feelings forming part of the narrative in box 3 of the record of inquest, the conclusion was materially incomplete and verged on misleading by omission. At paragraph 80, the court continued, it was not reasonable or lawful for the admitted shortcomings in Mr. O'Neill's medical care to be excluded from the record of inquest, so that the conclusion as to his death was merely described as natural causes. The material facts leading up to the deceased's death included substandard care by agents of the state, which, if they were to pass unmentioned, would render the bland, short-form, natural causes verdict inadequate to describe properly the circumstances in which the deceased met his death. So in just 2 paragraphs, paragraphs 70 and 80 of the judgment, the divisional court referred to the failure to include the delayed diagnosis as materially incomplete, verging on misleading by omission, inadequate and bland. So that seems to me pretty strong descriptors of what the court thought of excluding a delayed diagnosis of cancer due to prison healthcare failings. And it reminds me certainly of a jigsaw puzzle, because it seems clear from the judgment that the court considered the delay and the substandard care was such an important element of the circumstances of Mr. O'Neill's death that to exclude it or not mention it would be an incomplete picture. And for completeness, I should say that in Tainton, the court stated that they were not suggesting that any omitted feelings have to be included in every case. The manner in which the state discharges their obligation will vary from case to case. The position may be entirely different if, for example, there is a public query or a criminal prosecution. So Tainton was in June 2016, and we now fast forward to April of this year. So 4 years later, April 2020, we have the judicial review of Carol on application of Carol Smith. And in this case, Miss Smith was aged 27. She, in March 2017, collapsed at her GP surgery and was immediately referred to A&E. There she was reviewed and referred for paranoid beliefs. Her mental state rapidly deteriorated, but she was discharged from hospital later in March. She was visited by the out-of-hospital home treatment team on a number of occasions in April. Later in April, her medication was increased. However, she continued to deteriorate and took an overdose on the 17th of April. She was then again admitted to hospital. A psychiatrist was consulted, and it was considered that she was fit for discharge, and her medication was again increased. That discharge took place on the 19th of April. Then on the 25th of April, Ms. Smith was seen for the first time face-to-face by a psychiatrist, who again noted deterioration. And unfortunately, on the 28th of April, Ms. Smith hanged herself. She was taken to hospital and she died a few days later on the 2nd of May. The trust, whose name I cannot pronounce and will not try to pronounce, is pictured on the map in purple within Wales, and they concluded in their serious incident report that the root cause of this death was inadequate medical cover for home treatment team patients in the West. The Smith inquest was conducted by a coroner sitting without a jury. Article 2 was engaged and expert evidence was called. At the conclusion of the inquest, the coroner delivered her judgment or her reasons in 2 parts. Firstly, she delivered what the Divisional Court described as a carefully structured and reasoned narrative and consideration of the issues delivered orally and made available in writing, and that those decisions were 14 pages long, and she then completed the record of inquest. And in her oral reasoning, the coroner was critical of the trust, but ultimately concluded that these findings did not cause death. The record of inquest that was completed included these comments in box 3 and 4. And if you review those, and you have a very short time to do so, but importantly, on the record of inquest, there was no mention of any admitted failings, and there was no neglect rider that the family had been contending for, although the Divisional Court thought that ground was unarguable. But the application for judicial review that was heard in late March this year, just before lockdown, it was heard before Lord Dingman's, Mr. Justice Griffith, and the current Chief Coroner, His Honour Judge Ludcroft QC. And for today's purposes, the relevant question was the decision and were the record of inquests compliant with the requirements under Article 2? And at the heart of that were that the criticisms accepted by the coroner should have been included in the record of inquest. And Mrs. Smith, Carol Smith in this case, she sought a replacement of all of box 3 and 4 with a narrative that referred to the failings in care. The argument being that the criticisms accepted by the coroner ought to be included to fully reflect the circumstances of the death. And counsel for Mrs. Smith drafted a proposed answer to section 3 and 4. And this was produced on the basis of what the coroner had included in her reasons, with one small exception. And at this point, you might think, well, in Tainton, the court set out that without inclusion of admitted failings, records of inquests would be material, incomplete, verging on misleading, inadequate and bland, as I listed for you a moment ago. But the Divisional Court in Smith, which, as I say, included the Chief Coroner, they found the family's drafts completely inappropriate, and they thought it referred to or was more similar to a statement of case. And the Divisional Court said this: both the reasons and the record of inquest were delivered in public. Both, therefore, were part of the public record. The argument that more of what appeared in the reasons should have been repeated in the record has the appearance of an argument of form over substance, and we would reject it on that ground alone. The Divisional Court in Smith, they also referred back to Middleton, the early case concerning Article 2, and they said that even in a convention case, that conclusions still ought to be concluded briefly. And in paragraph 81, the court said this: it was neither necessary nor convenient for the points in the second paragraph of the draft to be added to the record. In our judgment, it would have been wrong to place them there. They would have been compromised. They would have compromised the essential brevity and simplicity required of a conclusion answering the question how, when, and where, and this being an Article 2 case, in what circumstances the deceased came by his or her death. It was correct for the points in the draft to be placed in the reasons where the coroner placed them, and not in the conclusion. And in that paragraph, paragraph 81, there is again reference to brevity. And the court also, earlier in the judgment, at paragraph 74, referred to the Chief Coroner's guidance and the need to be concise. And that Chief Coroner's guidance, although not specified, it must be guidance number 17, which deals with conclusions. That guidance was last revised in January 2016, and that predates the current Chief Coroner, who is pictured here. That predates his appointment. So that is, I think, of significant interest. So where do these two cases leave us now? There are a number of issues. Both of these cases, both Tainton and Smith, deal with admitted non-causative failings. The difference in the two cases is, of course, that in Tainton, the coroner was sitting with a jury, and in Smith, the coroner was sitting alone. Juries, of course, cannot record findings of fact anywhere else other than on the record of inquest. So that is the important distinguishing feature. Both these cases, I think, are very likely to feature in submissions to coroners in the future. And in Article 2 cases, where coroners are sitting alone, I think it will be of interest to see whether we get longer reasons and shorter records. In non-mandatory jury inquests, I think there may be more calls for a jury now, certainly from families. So that might be ground that is much harder fought. And when a jury is present in a mandatory or non-mandatory jury case, anyone representing an interested party should carefully review the jury questionnaire and make any necessary arguments based on Tainton as to what the jury should be permitted to return. And that is how the coroner will get these conclusions out of juries, by carefully worded questionnaires. So as representatives, we will have to carefully consider those. Another issue arising from these is the consideration of, will there be more judicial reviews on both issues? There is also a question of, if a coroner is sitting alone and delivers the oral reasoning, how useful will records of inquests be for those that study them for statistical purposes or looking for patterns or even historical societal changes? And finally, what I think we need all to be on the lookout for is updated Chief Coroner's guidance on conclusions. I suspect this is already anticipated once we have the Supreme Court judgment of Moen dealing with standard of proof in suicides. But we should also, I suspect, all look carefully to check whether there are any updates in the Article 2 section of that guidance to deal with the issues that we've just discussed this morning. And that is the conclusion of my section.
One thing that Susan and I just want to leave you with, which is this, that no matter how definitive the law may sound on all these areas that we've dealt with in relation to Article 2, every case is fact specific. And of course, your case may not look on the face of it like it's going to engage Article 2, but perhaps just because of the specific facts of the case, it can do so. So never be frightened to make those arguments that need to be made when the time arises. We'd just like to thank you everyone for attending this morning. We know it's like the last of the summer days for everybody before autumn really does hit. Thank you very much. You can find out more about our Inquest team, of course, on the 3PB website. We wish everyone a wonderful week and a very good rest of the day. And please do join us again for future webinars. Thank you.
Thank you, everyone.